Hello, thank you for joining us today. My name is Emily Neumann. We're coming to you live from Houston, Texas with the law firm of Reddy Neumann PC, where every week on Tuesday afternoons we provide you the latest updates on employment-based immigration and answer your questions live. Today I have with me Rebecca Chen. She's one of the senior attorneys in our office and will be helping me answer questions, and we'll be talking today about site visits. It's a FDNS national security process typically for H-1B visas. We'll talk about what to expect if you are part of one of those. We'll update you on the H-1B lottery for those that filed in the CAP this year, what's going on with receipt notices, when to expect to hear something if you've been selected. We'll also talk about an issue that comes up from time to time relating to driver's licenses for those that are on non-immigrant type visas and how the renewal process works, and the May visa bulletin, which came out recently, what we'll expect going forward on that, and of course we'll answer your questions. So Rebecca, I don't know if you want to kick it off and kind of let us know what's going on with the CAP and the H-1B receipts.
Yeah, so that's something that's on a lot of people's minds if you filed an application in the lottery earlier this month. So last week, I believe on Thursday, DHS did confirm that they had completed selection of the advanced degree cap, and they had already completed selection of the bachelor's degree cap. The total number of applications they received was a little over 201,000, I believe, which is about an 11,000 increase from last year. And we started receiving receipt notices by email for applications that were filed in premium processing starting earlier this week. So those will roll in typically for over the course of about 2 or 3 weeks. It's still very early in the process. DHS typically takes, I would say, about a month or so to send all the receipt notices for selected applications. So if you've heard of people receiving their email receipt notices but you haven't received yours yet, don't worry. There's still plenty of time. Typically the emails will be sent first, of course, for premium processing selected applications. For applications that were filed in regular processing, you'll only receive a receipt notice that's a hard copy by snail mail, so obviously those will take longer. We typically expect to receive those starting at the end of April through mid-May. And then for applications that were filed in premium processing that are selected, USCIS has confirmed that the 15-day premium processing clock will start on May 20th. So even though the receipt date, I believe, will probably say April 12th, don't expect to hear something in the next 2 weeks. So you can expect to hear something between May 20th and June 4th, which is when the 15-day clock expires. For unselected applications, unfortunately, it will take quite a bit longer probably to receive confirmation that your application was not selected. Those petitions, the whole petition gets sent back in the mail. Those usually will start coming in June, even July. But usually by, I would say, the end of May, if you haven't received a receipt notice, you can usually assume that you haven't received, your application was not selected.
One of the questions I've been getting about those premium processing emails for the CAP, in the email it says the 15-day clock starts from the date received.
Yeah.
So you're saying that that's not true, even though it's coming from USCIS.
Yeah.
They're saying it in writing. But the actual lottery or the actual adjudication won't start until May 20th, even though the receipt says otherwise.
Yeah, it's very misleading, and it's probably just their template language in their email receipts. Typically for every other type of application filed in premium processing, the 15-day clock does start from the receipt date. But for the CAP subject applications, USCIS announced, I believe on March 29th, that they were delaying the beginning of that clock until May 20th. So actually, in addition to that, May 20th is also a date to keep in mind if your application was filed in the lottery, but it did not request a change of status. So premium processing is being made available in kind of a phased way this year for the CAP subject applications. It's only available right now for change of status applications. For applications that were filed requesting consular processing, not a change of status, You cannot request premium processing yet. That will be made available apparently at the end of May also. So you can, if your application was selected and you receive a hard copy receipt notice, then you can send in a premium processing upgrade request at that time if you filed as consular processing.
So we don't have an exact date on that yet?
Not quite yet.
So if you requested a change of status but not in premium processing, can you upgrade now? When do you have to do that?
So you can upgrade once you know that your application is selected. So part of the upgrade request is including a copy of the receipt notice. So if you do receive a receipt notice for a selected application, you could request premium processing, but only if it's selected.
All right, and you know this receipt process does take time. We're very early into it. I keep track of what percentage of our cases have received receipt notices, and I do post that update daily on immigrationgirl.com. So as of today, only for premium processing cases that are master's cap or advanced degree, we've received about somewhere between 40 and 45% of our filings have actually received an email notification. We've only received a couple paper receipts for those types of cases because obviously snail mail takes longer than email, but we still have time to go. So just because we're at the 40-45% mark, that doesn't mean it's over. I get that question a lot on the blog is, it should be almost over by now. I think that last year master's cap applicants ended up about a 63% were selected. And this year they modified the selection process, and USCIS tweeted last week saying that their preliminary data showed that about 11% more master's cap applicants got selected this year because of the rearrangement of that lottery. So maybe that means we should be looking at closer to 70% chance of selection for master's cap. So if we're only at 40, we're just over halfway. So it's not over yet. Don't worry if you haven't heard anything yet. Site visits. So these happen basically as part of a security check, typically after an H-1B petition is approved. These are normally randomly selected, just kind of to spot check or audit to make sure that the information that a company provides in their petition matches what's happening in real life. So kind of what happens during a site visit, there's a lot of times two parts to it. First, they might contact your employer and they could do this by email, they could show up at the company location, or they could do a phone call. Just ask them basic questions about what the company does, where they're located, maybe take some pictures if they show up there. They usually come to talk about a particular employee, so they actually do select a name or a petition in order to do that site visit. And so for that particular worker, they might ask the employer to provide job title, salary information, maybe some recent pay statements or W-2, just to verify that what was said in the petition is actually happening. Now at the same time, some site visits go directly to the employee. So it's possible that the employee could receive an email asking for documents or with a list of questions for them to answer. They might receive a phone call, or they could be visited at their actual work site, particularly those in third-party placement where you're working for maybe a consulting firm and placed at a client site. The site visit might happen at the client site, and they'll come and ask you the same thing, like what's your job title, what are your job duties, what's your salary, show me your recent pay stubs. They want to make sure that you're actually in the position that your company said you were in, working and doing the job duties they said you would be doing, and being paid like the company said they would pay you. So I think it's part of kind of just verifying that they're actually complying with all of the H-1B requirements. And then sometimes they'll follow up with an email with even more questions about who's your supervisor, provide their contact information, how long have you been at this location, or when did you start employment? Has there ever been a time where your company didn't pay you? Kind of, it's a pretty long list of very random questions. But it's not really anything to be nervous about. If everything that's in the petition is accurate, then you should be able to very easily handle any site visit that comes your way. I don't know if you have any
Yeah, we have noticed definitely an increase in the past year in site visits, which we were expecting under this administration. I will say something that we have noticed is that don't expect necessarily the person who is conducting the site visit to be that familiar with your petition. What we've noticed in a couple of instances at least is there was an application that had an RFE, a request for evidence, had been issued, and the deadline for the RFE had not even come up yet, and a site visit occurred where there was a list of questions that were very similar to what was asked in the RFE. And in both cases, when we asked the officer conducting the site visit, can we just provide you this information as part of the RFE response, the officer was not even aware that an RFE had been issued. A lot of these officers who conduct the site visits are contractors and not employees necessarily of the service centers where your petition may be pending or have been approved. Sometimes they don't even have really a full copy of your petition in front of you. They're just told to, given a list of questions and told to collect this information from you or your employer. So just keep that in mind. If you're expecting them to be an expert on your case, they may not be. Just answer the questions to the best of your ability.
And I think that one thing to be aware of is what happens after the site visit.
Yeah.
99% of the time, nothing. You never hear back.
Right.
And no news is good news in that situation. If things went wrong during the site visit, it might be several months before any action is taken, and typically that would be a notice of intent to revoke,
Right.
Where the service center officer will now explain what happened in the site visit, why they think the company's not in compliance, or maybe the terms and conditions don't match what were listed in the petition, and then the company has 30 days to respond to that and explain the situation. So most of the time, you never hear anything after a site visit, and that's
Right.
totally normal. That's a good sign. How about driver's licenses? I know it's kind of different for every state.
Yeah.
What are some issues that can come up, especially in the situation of maybe an extension that's pending?
Yeah. So driver's licenses for non-immigrant visa holders. Something that if you're on a non-immigrant visa, something that you are probably aware of if you've tried to renew your driver's license while you have an extension pending, is that a lot of driver's license offices will not accept a receipt notice as proof of status or proof of authorized stay here in the U.S. Each state is a bit different in their rules on what they're supposed to accept from aliens renewing their driver's license. In Texas, at least, they are supposed to accept a receipt notice for a pending extension. In practice, what we've observed is that most DMV offices and the employees who work there don't know the difference really between a receipt notice for a pending extension and an approval notice. What seems to be the training that they receive is that they're told to accept only an original I-797 approval notice with the I-94 attachment at the bottom, or some other original document like an EAD card. For that reason, we normally recommend that if you are coming up to the point that you need to extend your H-1B visa or other type of non-immigrant visa, do it early. That's something that we mention all the time, to extend early, file in premium processing so that you can get that extended approval notice well before you need to renew your driver's license.
Yeah, and I know specifically in Texas, this has come up in previous years for those with the cap gap, extension of the F1 status while you're waiting for your H-1B approval. Typically, the driver's license office wants to see the EAD card as proof that you have status, and when you show up with an expired EAD card, because you've got the cap gap authorization, they're just not familiar with it at all. And they'll go to that save verification process and wait 3 weeks and then tell you, yeah, we can't accept anything. The only thing you can do is provide us the H-1B approval notice. So if you're in that kind of situation where your driver's license is expiring or has expired because your OPT has expired, even though you have the cap gap work authorization, you may want to consider premium processing your H-1B if you didn't already. so that you can get that H-1 approval notice, which will then allow you to renew the driver's license, which is a very expensive way to renew your driver's license, but that seems to be the only way. Again, it depends on the state, but. And then one other thing we wanted to discuss before we get into the live questions is the May Visa Bulletin that came out from the Department of State. Not a lot of shocking news there other than the fact that nothing is moving. There's no forward movement, very little in most of the backlogged categories, and everything else that's been current is remaining current. We do know that USCIS confirmed for employment-based applicants, you have to use the final action date chart. They're not allowing us to use the filing dates chart anymore. That I think is going to continue until October is my guess. That seems to be that they allow it for just a very short window and then it's gone for the rest of the fiscal year. One thing in the Visa Bulletin this time around is kind of a note if you scroll down a little further, specifically for EB1, regarding the high level of demand they're seeing for EB1 applicants filing adjustment of status in the U.S. It's so high that they're thinking that they're going to have to retrogress that category even more than it already is, just in order to limit the number of new filings that they're receiving. So they didn't give us an idea of how far back they will retrogress it or when. I would expect it sometime June, July, August, or September. I know that's not super helpful, but they did say that October 1st, which is the October Visa Bulletin, is next year's visas. Whatever it retrogressed should come back to where it is today on October 1st, which also isn't super helpful because it's very backlogged today. But this seems to be the new normal for EB1 now. I don't think we're going to get to a situation where it's current.
It's not moving, unfortunately, for India and China especially.
All right, let's go to some questions here. So question I have on Facebook from Niti is about H4 dependent child who's in high school. Can they work? Can they get a summer job? Can they do an internship to try to gain some experience in the real world? Unfortunately, no. The H4, regardless of whether you're a child dependent or a spouse dependent, there is no work authorization for children specifically for that when you're in the H4, and even if it's volunteering without pay, if you're getting any kind of benefit from it, it is considered work without authorization. So unfortunately, no, there's not an option to do an internship or take a summer job or anything like that while you are in H4 going to high school.
From YouTube, we have a question from Ram. Is it legal to travel while the H-1B transfer is in RFE, but the H-1B visa and I-94 from the previous employer are still valid? So this is an issue that we're asked about a lot. Can I travel while I have an application pending? In this particular situation, although technically it may be possible since the previous H-1B approval is still valid, technically it's supposed to be possible when your transfer is pending to leave the country and re-enter with your previous employer's H-1B approval and the receipt notice for the transfer. In practice, we don't recommend it for multiple reasons. One of them is that that can easily result in an I-94 mismatch, which we've discussed in these sessions before. Basically, when you re-enter the country, you're given a new I-94 number that is not going to match the I-94 number that was submitted in your pending transfer application. If it has an RFE, there may be an opportunity in the RFE response to send the updated I-94 and update the I-94 number that way. In general, though, it's pretty risky. We would advise that if you don't absolutely need to travel while an application is pending, that you just respond to the RFE, upgrade it to premium if you need to, wait until it's resolved, and then travel. An issue that is a bit tangential to that is that CBP announced that starting next month, actually I-94 numbers will become alphanumeric. So if you're familiar with the I-94 record that you access electronically every time you enter, there's a string of numbers at the top. That's your I-94 number. It's 11 digits. Starting next month, the 10th digit will be a letter. Apparently, they've run out of all the numbers available. So if you are accessing your I-94 starting next month, if you've entered the U.S. starting next month, you access your I-94, there will be a letter there probably, and that will be the way it should be. Don't think that it's a typo.
Yeah, and kind of going back to our driver's license issue that we talked about, I think that traveling while you have something pending and causing that I-94 mismatch is likely to come up if you have to renew your driver's license after that, because they're going to be looking at the most recent I-94 number, which may not be the one you get from USCIS might be different than the one you got from CBP, and it's going to be very confusing for them. So
Yeah.
definitely something to avoid there. Sandeep from Facebook has a question on the timeline for hearing back on a request for evidence after you respond to it, specifically from the Vermont Service Center. In regular processing, it's typically around 60 days, maybe a little bit longer. I think with both service centers, I think 60 days is normal. So if you responded in February, pretty soon you should be hearing something in regular processing.
We have a couple questions on H4 EAD. Just, I assume, an update on the regulation at OMB or the litigation. As far as I know, there hasn't been any movement on either of those. Is that correct?
As far as I know, there have not. With the OMB, it's just kind of it could be any day now. It's been pending with them since late February, so we're getting close to the 60-day mark. That being said, they have some things that have been pending with OMB for their review for 10 months, 8 months. So it's not out of the ordinary that it's still stuck there. And I think on the litigation, we're not really going to expect anything coming as far as a decision for several months. I mean, we're just at the very early briefing stages, and then the judge has to review all the briefs, and then there's probably going to be motions and different motions and counsel adding in and counsel taking, moving out. So several months, I'd say at least 6 months on the litigation for us to hear anything on that. One of the questions on Facebook is, what is an NOIR? So I kind of talked about that a little bit earlier. That's a notice of intent to revoke. That is something that happens after you've already received an approval of some sort of application. So in the example of an H-1B petition, you may have received your H-1B approval, and then for some reason a month later, or it could be 2-3 years later, USCIS finds something that is derogatory or bad information about what was submitted, or maybe a site visit revealed new information, maybe a visa interview at the consulate revealed some new information that's not matching what was in the petition. And their way to do that is to basically reopen the H-1B adjudication process and issue an intent to revoke. That means they're intending to wipe out that prior approval and revoke the approved petition. So it's basically like it was never approved before. Definitely needs to be taken very seriously, and the time frame for responding to it is only 30 days. So by the time you get it in the mail and send it back, you probably only have 2 weeks to prepare a response to it. Now, once you respond, the timing for them to reaffirm the approval or revoke the approval could be months. It's not a fast process. I'd say at least 60 days, could be 6-8 months. But that's what a notice of intent to revoke is. It can happen with an approved I-140, approved I-129. What we saw from last year's CAP cases is a number of petitions got approved very early in June, without any request for evidence, and then they went back later, issued notice of intent to revoke, saying now all of a sudden we are questioning whether this is a specialty occupation. We think we approved it in error. Now prove to us that it should have been approved.
Right.
So it's kind of a weird process. I don't think I've ever seen them do that with like a mass number of cases.
Yeah.
But we're in kind of a new era, so every day it seems like something's different.
Sumit from YouTube asks whether an H4 and EAD should be filed along with an H1B extension that's being filed in premium processing. So as we've been mentioning for the past month or so, because of this new I539 form that requires biometrics for anyone using the I539 form, we still are not exactly sure how premium processing concurrently filed H4s and H1Bs will be treated in that situation. I think we had like a test case that you filed, well, not a test case, but a case that we filed H4 with the H1B in premium processing, and the biometrics was scheduled, and the H1B was approved within the 15-day clock, but it's still yet to be seen how quickly the H4 will be adjudicated. Is that right?
Yeah, I think later this week is the actual appointment, so we'll be keeping tabs on when we actually see the H4 approval after the biometrics are actually done. One thing I want to mention on this biometrics, in the I539 form, you have an option to list both a mailing address and a physical address. We have learned that USCIS uses the mailing address to decide where to schedule your biometrics appointment. So if you use a mailing address that's in a different city far away, maybe, I don't know, maybe you and your spouse work in different places during the week, and then you have a permanent address that you go to on the weekends or something, and you use that as your mailing address, but your physical address is elsewhere, they're scheduling you for biometrics where your mailing address is, not where you're physically located, which I think is dumb.
Yeah.
I didn't have a very nice conversation with an officer today that I discussed that with. They didn't enjoy my
take.
Yes. So just keep in mind that be careful if you are using a separate mailing and physical address. If you can avoid it, just put a physical address or use one address for both physical and mailing wherever you're located, so that you'll be scheduled in the right place.
That being said, if you do miss your biometrics appointment notice for some reason, or you need to, if you've missed it or it got sent to the mailing address anyway, it's possible to reschedule the biometrics appointment. It's not too complicated, it's just the delay. Some service support centers will allow walk-in appointments also. So if they're not too busy, if you go early in the day when they first open, and you have the appointment notice and you explain that you missed your scheduled appointment, a lot of times they will allow you to just have the appointment done right then.
Divya has a question on Facebook. Filed an H-1B amendment in premium processing that was received on April 8th and still no receipt number. When does the clock start? It should start the day it's actually received. So the fact that you haven't received an email notification or a receipt number yet is not a good sign. Typically we get it within just a day or two after it's delivered, unless it's over a weekend. So something may be amiss. I would definitely check to see whether the premium processing filing fee has been cashed. If it hasn't, your employer or their attorney can email the premium processing unit and ask what's going on. Say, we've delivered this petition on April 8th, here's the FedEx tracking number, what's the receipt number? And they usually respond within a day, letting you know the receipt number. Or if it was rejected for some reason, they'll let you know it was rejected, and you can expect that to come back in the mail and have to resubmit it again.
Prashant has a question. He applied, his application was submitted in the lottery this year with his primary employer, but he says he is working for multiple employers on OPT. Can he continue to do so until September 30th? So that is, yeah, that's kind of tricky. We normally recommend that H-1B applicants work primarily for the H-1B petitioning company. It's just much simpler and much cleaner that way, especially if there's a request for evidence. Typically they're asking for evidence of the specialty occupation work, and it's obviously much easier to respond to that type of RFE if you are actually performing specialty occupation work with that company at the time, and you can provide examples of your work product and exact descriptions of your job duties. Having said that, theoretically, it's possible to continue working for a different employer. The effective date of the H-1B technically is October 1st, but yeah, we don't recommend it for those reasons.
Gautami has a question about applying for an H-4 visa stamp through consular processing when an H-4 extension and EAD are already filed and pending. Yes, you can do that. You know, if the processing time is super long for the I539 for your H-4, maybe it was filed separately from an H-1B, you can definitely, even after you filed that H-4, go ahead and travel and get the visa stamp. I would warn you that you may have to refile the EAD when you come back. You know, we don't know exactly how USCIS handles that situation when they're adjudicating the EAD. So I would just be careful of that and just plan on filing it again as soon as you return, and then waiting the 3 or 4 months to get that approved.
Supreet asks if it's risky to change companies with just a receipt number, or should he wait until the final approval? So this would be, I'm assuming, an H-1B transfer situation where you're authorized to work for the new company based on their filing the application for you. So once you have the receipt notice from that transfer application, you're authorized to work for the new company. For much of the past year, we've been advising caution in that situation because premium processing wasn't available for several months. And the reason for that was, without premium processing, if you transfer right away based on the receipt notice and something does go wrong with the application, it eventually gets denied, it's potentially several months that you're out of status automatically upon the denial. Now that premium processing has resumed for all types of applications, including transfers, it's always safer, of course, to wait until the approval notices come in if you're able to wait. File in premium processing, and potentially 2 weeks later, if there's an approval, then you can start at the new job with, you know, assurance. But if time is of the essence, I would say now, because of the premium processing availability, it's not as risky as last year to start with the new company right away.
Surjit has a question about I-140 and wants to know what are the things USCIS looks for when they're trying to decide whether to approve one or not. So there's basically 3 things. Number 1 is, do you have an approved labor certification if your category requires a labor certification? Number 2 is, do you meet the requirements for the job that were set out in the labor certification? So the labor certification will usually say what the minimum requirements are for a specific job that you're being sponsored for in terms of education and experience. So for example, your labor certification might say that the job requires a bachelor's degree in a specific field and 5 years of experience. Now you have to prove that you meet that requirement. So you have to submit copies of your education documents to prove that you either have a U.S. bachelor's degree in that field or the equivalent of a U.S. bachelor's degree. And then you have to submit experience letters or employment verification letters from your prior employers to prove that you have the 5 years worth of experience. One thing on that, on the education requirement, you know, on an H-1B, for example, USCIS will accept a 3-year bachelor's degree combined with experience to meet a bachelor's degree requirement. That's not the case for the I-140. So if you don't have a 4-year bachelor's degree that's equivalent to a U.S. bachelor's degree by itself, you may have an issue there. So that's one thing to keep in mind for those with a 3-year bachelor's degree. And then the last thing they look at is, does your company have the ability to pay the wage offered? That's typically done by submitting your pay stubs and W-2 forms and then the company tax return. And then in some situations, they want to verify that it's a bona fide job opportunity. That's kind of a newer issue that keeps popping up, especially with consulting firms, I would say, where they're saying that work will involve unanticipated locations, or you could be moved around to different locations. They're questioning kind of, is the job a valid job if you can't tell me where this person's going to be working from one day to the next? So those are probably the top issues that USCIS looks for. They do not look at anything related to maintenance of status. It's not, you're not asking them for status based on your I-140. So you don't submit any of your visa documents. You don't have to prove maintenance of status, because remember, an I-140 can be filed for someone who's outside the country. So obviously they wouldn't have to prove maintenance of status. So this is just a petition to prove that you qualify as an immigrant worker and your company has the required labor certification.
Sarisha asks, if an H-1B lottery application is selected, can I move to a different location within the same company or employer before the H-1B effective date? So that's a bit tricky. In general, we recommend, if possible, for there to not be any changes to the terms of employment that were listed in the H-1B application until after October 1st, when the H-1B is hopefully is approved, has gone into effect, and then an amendment can be filed or transferred to another company. I would say in the situation of moving to a different location of the same company or employer, it may not be, I would say it's less risky definitely than moving to a different end client location. If you worked for a consulting company, moving to a different end client location from the one that's listed in your pending selected application is going to be, that will be a much more risky situation, because if you get a request for evidence, usually it's requesting evidence of the project that you are no longer on. In this situation, if it's a different location of the same company or employer, definitely, I assume you're working on OPT, work authorization. There's nothing in the OPT rules that prevent you from moving to a different location while you're still in F1 status on OPT. The only issue would be if you do get an RFE, if it happens to be location specific for some reason for that company, the company will just need to show that they do intend to move you back to that initial location starting October 1st. So it'll be up to whether the company is able to provide evidence of that.
Vivek has a question. He's got an approved I-140, got it over a year ago, is thinking of returning to his home country and wants to know if later on, if he gets a new job offer, can he use that approved I-140 to get an H-1B without going through the lottery? And the answer is yes. Since the I-140 was approved and valid for at least 180 days, even if the current employer withdraws, even if you're outside the U.S., at any point in the future, you can use that approved I-140 to get a consular processing up to 3-year H-1B approval with any company. And there's no time limit on that either, except that once the priority date is actually current, then you're only eligible for a 1-year H-1B. So that is something to be aware of. And then to be able to actually get the green card, your new employer then has to file new labor certification, new I-140, and then you can file the 485 once you're here.
This question is on the options for an H-4 visa holder to work if and when the EAD is eliminated, and if H-4 to F1 is practically not possible. Yeah. So it is very difficult, unfortunately, in that situation. If and when the EAD does get eliminated for H-4 visa holders, there won't be that many options, unfortunately. Earlier this year, in February and March, when we did receive news of the regulation going to the OMB, we did start advising people who have an EAD in H4 visa status to consider starting to apply in the H-1B quota or in the lottery this year, since H-1B seems like the main other option for work authorization for people in that situation. But if you've never held H-1B visa status before, obviously you'll have to go through the lottery. If you applied in this year's lottery and were not selected, hopefully the EAD will still be available next year when you can hopefully try again in the lottery. And if not, then if you didn't apply this year, hopefully you can try applying next year.
Yeah, and I think the change of status to F1 is going to be tough
Yeah.
because you've got immigrant intent, given that your spouse has an approved I-140, since you have the H4 EAD. You know, we see a lot of people doing these day one CPT as a way to be able to work while you're studying. That's very risky. If you try to get the F1 visa stamped at the consulate, you might have the issue with immigrant intent.
Yeah.
So F1's probably not a great option. H1, if you can qualify for it and make it in the lottery. O1, potentially, if you meet those requirements. And L1, I suppose, if you want to work outside the U.S. for a year.
Yeah.
Very limited options for sure. So please be prepared to comment on the proposed regulation once it comes out. I did issue a very detailed report on the reason we need to keep the H4 EAD. You can find that on immigrationgirl.com, and I'll be using a lot of the statistics from that report in order to support the commenting process once that becomes available. So just stay tuned for that. Vipul from Facebook has a question on what are some of the common causes of a 221G at the consulate. It's hard to say because most of the time we don't know. It just is this random administrative processing. It could just be they didn't have time to look into the file and the officer's too busy, so now they're going to take the time and do it later. It could be some sort of, they just want to verify things. The consulates send a lot of things to the Kentucky Consular Center, which has its own fraud detection unit. So they might be checking into things to make sure there's no fraudulent documents, fake end client letters, and that sort of thing. Sometimes the 221G actually asks for specific documents, and then you know that's what caused it, because maybe they wanted, maybe there wasn't an end client letter in the petition filing, and now you're showing up with for your visa interview without. Or maybe you're working at a different client now and an amendment wasn't filed, so they know nothing about that employer-employee relationship and that chain of contracts. Also, it can come up in the situation of, I believe it's called a mantis check, which is for someone who has like a biotech type background. If you studied in that area, you might have to get a special clearance because they want to make sure that you're not coming into the U.S. and developing some super germ that's going to kill us all. Not to make light of that, but it is a real security concern, so sometimes there's an extra check required for that. It can take several weeks. I'd say those are the most common issues that come up with 221G.
So someone asked if, can I continue working until I get my H4 EAD extension? I assume that what Hema is asking is if her current EAD has already expired and she's applied for the renewal, but it hasn't arrived yet. Unfortunately, there are some types of EADs where you can continue working based on the pending I-765 that was timely filed. H4 visa holders, unfortunately, are not one class of EAD holder who can do that. You need the renewed EAD in hand before you can continue working. So that's another reason to file extensions and renewals early on, and to file in premium processing if possible, so that you have plenty of time to get the renewed EAD.
I have two questions on the biometrics. The first question is, does it have anything to do with EAD or EB3? No, the biometrics requirement is currently just for those that are filing an I539. So that is for people who are filing for B1, B2, F1, F2, H4, L2, TD, E3D,
I think that's
O dependent, O3 dependent. So it's only if you're filing the I539, then the biometrics is required. It doesn't have anything to do with the EAD. That's a separate application. The other question on the biometrics is, since we're getting it for the I539 and for H4s and L2s, is it going to be something that they're going to start for other categories like the I-129? I would say very likely. That's my guess. I mean, the whole reason they did it is so that they can have the biometrics of the people that are in the country. And so if you're only getting the biometrics of some people and not others, I think it's very likely that all other categories, all other types of filings are probably slated to get the biometrics required as well. Paresh has a question on Facebook. Can an H4 visa holder travel while the H1B is in process and apply for the H4 stamp at the consulate in the home country? I'm assuming the H1B requested consular processing, and if that's the case, yes. You can go out, get the H4 stamped, and come back in, and then once your H1B gets approved, you go out, get the H1B stamped, and come back in. If you requested a change of status from H4 to H1, be aware that when you travel, you're going to abandon the change of status portion, and then it turns into a consular processing H1B approval. So that would be the only issue, but no issues with getting the H4 stamped as long as you're married to an H1B holder and your H1 spouse is maintaining status. There shouldn't be a problem with that. Amit has a question. Would it have a better chance of approval, I'm assuming this is for an H1B, with a computer systems analyst or a software developer? It really depends. I tend to prefer, I feel like we have fewer issues with software developer compared to computer systems analyst, but I think the wage level is also important. If you're talking about a level 1 software developer versus a level 4 computer systems analyst, probably about the same chances of being approved. So it's more than just the SOC code that's relevant there. Really depends on the job description, is a detailed job description, and the wage level is also a factor.
Barath has a question on his pending H-1B amendment. And so there's a pending H-1B amendment, but he would like to transfer to a new employer. So whether he can do that. It depends a lot, I would say, on whether your I-94 with your current employer is still valid. If it was filed as an amendment plus extension and you're past the I-94 expiration date for your current employer, it's much more risky to file a transfer in that situation because you're in a period of authorized stay that's dependent on that pending amendment plus extension. If your I-94 from the underlying application with your current employer is still valid and it's just a straight amendment that's pending to amend your work location or some other term of your employment, an H-1B transfer should be fine. You're able to provide pay stubs to show that you're still working and maintaining status with your current employer. So yeah, it'll depend on whether your I-94 is still valid.
I had a question on Facebook about the current processing times for EB1. Really depends on the service center. It could be anywhere from 4 to 12 months. The Texas service center is a little bit faster. Nebraska is close to a year on those, particularly for EB1C, multinational executive or manager. Those are 9 to 12 months in Nebraska.
Lance has a question on whether you need to follow the wage level when filing an H-1B extension. I assume you mean whether the extension application has to be filed at the same wage level as the already approved application. No, not necessarily. If the term of employment is changed, if the salary is higher than it was when the first application was filed, 2.5 years ago, definitely, mark the higher wage level in the LCA for the current employment terms. Technically, it could also go the other way. The salary could be revised down, although, of course, it's not grounds for denial just based on that, but it may be a little more risky since, of course, we've known since 2017 that lower wages are a higher target for RFEs and scrutiny.
Kunal from Facebook has a question. His I-140 is approved, filed an H-1B extension, which is pending. The I-94 expires. And then if the H-1B ultimately gets denied, does it have any impact on the I-140? No, the I-140 remains approved. The priority date is not impacted at all. It has no impact on the approved I-140, even if the H-1 extension happens to get denied.
And then Amrith has a question about TNs. Can they be renewed indefinitely, or are there any limits? So the TN visa is for nationals of Canada or Mexico for professional occupations. Unlike the H-1B, which has a 6-year limit, TN visas do not have a set limit. Technically, they can be renewed indefinitely as long as you are able to prove non-immigrant intent. So unlike the H-1B, which allows you to have the green card process ongoing at the same time, you're allowed to have the intent to stay in the U.S. permanently while you're on an H or L visa. The same does not apply for the TN, so that is a drawback. You can theoretically renew it indefinitely, but you can't really start the green card process, or if you do, you have to time it very carefully. So because of that, if your ultimate intention is to have the green card filed on your behalf by an employer, a lot of times we will transition a TN visa holder to an H-1B visa holder so that they can start the green card process.
Yeah, that's specifically for someone who was born in India, for example, a retrogressed country, and then obtains Canadian citizenship, to where there's no way they can maintain the TN long enough to get the green card. Sachin from Facebook has a question. Is there a need to apply for H-1B visa stamping if someone has the I-131 approved? So this is someone who's filed the adjustment of status, it's pending, received their EAD card, and received the advance parole along with it. Once you have that, do you have to go for H-1B stamping if you travel? No, you don't. You can instead use your advance parole to enter the country and then use your EAD in order to continue working. So no, it's not required for you to do that. It's kind of a choice you have to make. Partially it depends on whether you have a H-4 dependent who has not been able to file the 485, for example. That happens from time to time, where the main applicant files and then you get married, and by then the date retrogresses, and so your H-4 can't file, so you have to maintain the H-1 in that situation. So that happens from time to time. Or if there's something in your 485 that you're questioning, maybe there's a chance of denial, you might want to stay on the H-1 instead and continue maintaining your H-1B status so that the denial of the 485 doesn't put you out of status. Especially, we have the NTA memo specifically for 485s. It doesn't apply to I-129s yet, but if you filed your 485, your adjustment of status, and it ultimately gets denied, and at that point, if you don't maintain your underlying H-1 status, that denial puts you out of status, you're immediately unlawfully present, and an NTA, notice to appear in immigration proceedings, could be issued within 30 days. So that's a big risk to take. If there's any concern that your 485 might be denied, I would definitely discuss with your attorney about whether it's better to maintain the underlying H-1 status and go ahead and go for H-1 stamping even though you've got the advance parole.
Swati asks if she has a master's degree from a U.S. university, but she's currently on H-4 status because her OPT expired. And can she apply for the H-1B in the master's category next year? Yes, definitely. So applying in the advanced degree cap in the lottery is not dependent on being on OPT or being in F1 status. The only requirement is that you have a master's degree from a U.S. university. So even when you're in H4 status, if you have that U.S. master's degree, you can apply in the advanced degree cap.
Supriya from Facebook wants to know if it's safe to travel when you're on F1 with an approved OPT card and your H-1B is in consular processing. It's technically possible to travel. Whether it's safe is a different question, because when you are returning into the U.S., you're returning as a student, you have to demonstrate to the officer at the port of entry that you are intending to study. But at this point, your program's over. You're just coming to work. You have this H-1B that's on file proving that you intend to work. So you may have difficulty getting past CBP. And then if you need a visa stamp, maybe your F1 visa stamp's expired, you also have to do the same at the consulate. So you may have trouble getting back in F1 status because you have now the plan to work, and they want to know that you have that non-immigrant intent, that you intend to return to your home country at the end of your OPT time. Having an H-1B on file suggests otherwise. Now it's a little bit better in this situation because it's a consular processing H-1B. You can say, yeah, I'm coming in now to finish my studies through my on-the-job training, and then I'll return back to my home country when that's done, and then later, if my H-1B is approved, I might come back to work. But right now, my intention is just to finish my F1. So something to definitely discuss with your attorney before you travel. Any travel situation, talk to an attorney before you make your travel plans. One of the attorneys in our office was just telling a story today of someone who did not talk to an attorney in our office and left, and may have unknowingly triggered the 3-year bar because they didn't check with us first. So obviously that doesn't apply to everyone, the 3-year bar and all those intricacies, but immigration law is very complex. And so if you're traveling, that's definitely time for you to talk to your attorney and make sure it's okay to travel before you leave. Don't do it after you've already left. Maybe it's time for one last question. I don't know if you have any lined up over there.
Just a really quick one. Someone asked if it's true that you can go to Canada or Mexico for a week and come back without needing a consulate visa stamp. Yes, that is a provision called automatic revalidation, which we've discussed before. There's also an article on our website describing the specific criteria, but it applies to travel of less than 30 days to Canada, Mexico, and some other adjacent islands. It is only available if you have an approved, a valid I-94, so like the I-94 card attached to an I-797 approval notice, and if you do not try to apply for a visa stamp at a consulate. So it does not work if you travel to Mexico, for example, you try to apply for a visa stamp there, and then if you get a 221G, you cannot then try to re-enter the U.S. using automatic revalidation. It only works if you have not tried to apply for a visa.
All right, I think it's about time to wrap it up. Thank you so much for joining us today. If we didn't get to your question, I want to let you know that we do have a daily conference call that's free. The dial-in information is on our website at rnlawgroup.com. You dial in, it's every day, and you can talk to an attorney and ask your basic questions there. If you'd like more detailed discussion with one of our attorneys and would like to set up a consultation, you can do that at rnlawgroup.com as well. Click on consultation or appointments. You can see all of our schedules and all of our attorneys that are available for that. If you're waiting for your H-1B receipt notice, your lottery results, keep checking immigrationgirl.com. I update that pretty much every day with the progress of our own firm's receipt, so you'll have an idea of when you might be able to expect yours, and I start updating when we start getting approval notices, talk about the different RFE trends that we see this year, and just keep you updated on what's going on with the whole lottery process. So thank you for joining today.